I'm sorry to interrupt you. We have the order copy on timestamp. First to tell you the verdict, first to access the order copy. And here it is. And we'll be putting that on screen. And let me read it verbatim. The application 35C filed by the defendant number 4 under order 7 rule 11 CPC is hereby dismissed. Fixed 22nd September 2022 for filing written statement and framing of issue. The applications pending under order 1 rule 10 by different applicants shall also be disposed of on this day. Signed by the district judge of Varanasi, Dr. Ajay Krishna Vishvesh. With the date. The order copy here with timestamp. We'll put that on the big screen. Padmaja Joshi, our executive editor, with us. Yes, Padmaja.
All right, we've got the operative part of the order today. Very significant. Let's take our viewers through the entire text of what we have so far. The order that we have says in section 4 part 9, temple has been defined as temple of Adi Vishweshwar, popularly known as Sri Kashi Vishwanath temple, situated in the city of Varanasi, which is used as a place of public religious worship and dedicated to or for the benefit of or used as of right by Hindus as a place of public religious worship of the Jyotirling and includes all subordinate temples, shrines, sub-shrines and the asthan of all other images and deities, mandaps, wells, tanks and other necessary structures and land thereto and additions which may be made thereto after the appointed date. From the perusal of the above mentioned provisions of the Act, it is clear that no bar has been imposed by the Act regarding a suit claiming right to worship idols installed in the endowment within the premises of the temple or outside. Therefore, defendant number 4 failed to prove that the suit of the plaintiffs is barred by the UP Sri Kashi Vishwanath Temple Act 1983. I repeat, defendant number 4 here, remember, is the Muslim side or the mosque side in this particular plea. Defendant number 4 has failed to prove that the suit of the plaintiffs is barred by the UP Sri Kashi Vishwanath Temple Act 1983. In view of the above discussions and analysis, I have come to the conclusion that the suit of the plaintiffs is not barred by the Places of Worships Act 1991, the Waqf Act and the UP Sri Kashi Vishwanath Temple Act, and the application 35C filed by the defendant number 4 is liable to be dismissed. The application 35C filed by defendant number 4 order 7 rules 11 is hereby dismissed. Fixed 26 September for filing written statement and framing of issues. The applications pending under order 1 rule 10 by different applicants also stand disposed. In a nutshell, what the order here says very clearly is that you have failed to prove, the Muslim side, the mosque side has failed to prove that the plea by the petitioner is saying we want to go and have a survey done of what we claim is a Jyotirling, is a Shivling inside the premises of the mosque does not run counter to either the Places of Worship Act or the Waqf Act or the Kashi Vishwanath Act. Back to you.
Absolutely. Thank you for joining us, Padmaja. We'll keep coming back to you as we get more pages. In fact, yeah, you have that.
We have the other page. We have the other page. And the first details being broken now on Times Now. Disposal of application 35C. Why was it disposed? Let's take our viewers through the details. Application 35C has been filed by the defendant number 4 under order 7. Rule 11D of CPC. In this application, the defendant has prayed that plaint in this case is barred under order 7 rule 11. Therefore, plaint be rejected. In the application 35C, it has been mentioned by the applicant defendant number 4 that the suit has been filed by the plaintiff for declaration that they have right to worship God at plot number 9130. Defendants be restrained from interfering in the worship, etc. The defendants also be restrained from demolishing and destroyed any part of it. It has been narrated in application 35C that Gyanvapi Masjid is established at plot number 9130 since about 600 years and it exists there till today. In this mosque, the common Muslims of Varanasi and nearby areas have been offering namaz of 5 times and namaz of Eid and Jummah without any interference. The Parliament has enacted Places of Worship Act in 1991. In this act, it has provided that places of worship will remain in the same position, etc. Then they also further elaborate on Kashi Vishwanath Act enacted by Uttar Pradesh government in 1983. In the Kashi Vishwanath Act, it has been provided that Board of Trustees deities will be created which will look after Kashi Vishwanath Mandir and all gods and goddesses. It has been mentioned in application 35C that from the perusal of the plaint, it is clear that facts mentioned in para 1 to 14 relates to Gyanvapi Mosque, and reference has been made regarding worship at Gyanvapi Mosque, which is situated since 600 years, and such assertions are barred by Places of Worship Act. In para 29 of the plaint, it has been mentioned that building complex is under the control of Masjid Intizamiya Committee. Therefore, it is clear that the whole plaint relates to Gyanvapi Mosque, which is a clever drafting. Very interesting here. Therefore, it is clear that the whole plaint relates to Gyanvapi Mosque, which is clever drafting. Essentially, here in this part of the order, the judge has laid out all of the objections which were there to the maintainability of the plea by the Hindu side, Pranesh. So the judge examined all of these arguments which are given here, and he says this seems to be clever drafting. You have quoted three main laws which this plea runs counter to, which is the Places of Worship Act, the Kashi Vishwanath Act, and the Waqf Act. And the judge subsequently has read all of this and said none of these three acts can stop these applicants from asking for a survey and their right to worship inside Kashi Vishwanath. Back to you.
Sir, absolutely. So that's the key takeaway as far as the Hindu plea is concerned. The court has said that the defendant failed to prove plea barred by Worship Act, by Waqf Act, and by the Kashi Vishwanath Act. I believe we have access to another page. Let's go back to Padmaja. Yes.
That is correct. So they go on to now, elaborate on what are the different papers and documents and arguments being given by the mosque committee, the Anjuman Intizamiya committee, mind you, to be specific. The petitioner number 4, or the number 4, party number 4 here is the Anjuman Intizamiya Committee. Anjuman Intizamiya Committee has filed papers with list 100C, which include copy of judgment and order dated 17 May 2022, passed by the Honorable Supreme Court of India in special leave to appeal, Committee of Management and Anjuman Intizamiya, Varanasi versus Rakhi Singh and others. That's the 5 ladies. Copy of office memorandum, etc., etc. They've given all of this. Defendant number 4 has filed 10 papers with list 22220C, photostat copy of map of Bandobast, etc., etc. Maud Sheher Khas Pargana Dehat Amanat, District Banaras, photostat copy of Khasra, District Banaras year 1291 in Urdu, in English. So basically, again, all of this goes on to say, and I'll just read out one small part, Swati. The plaintiffs have further submitted in their reply that from catena of decisions as mentioned in para 42, it has been established that an exercise of powers under Order 7 Rule 11, the court is not required to go into the averments made by the defendants in their written statement or in any application, and only the averments made by the plaintiffs have to be taken into consideration to decide the applicability of aforesaid provisions. In view of the law propounded by the Honorable Supreme Court, the present suit cannot be dismissed in exercise of powers under Rule 11 of Order 7. It has been prayed in reply 39C by plaintiffs that the application filed by defendant 4 under Order 7 Rule 11 is misconceived, it is not maintainable, and therefore it is liable to be rejected. So we gave you the operative part, we gave you the objections and the papers and documents that were filed by the Anjuman Intizamiya Committee, and these basically are the arguments which were given, which are a part of the order, which were made by the Hindu side, saying that this is what we have in our favor, and all of these objections are not applicable and they are liable to be rejected, and the court has ruled in their favor. Back to you.
Absolutely. Padmaja, thank you very much for explaining in detail the operative part and the grounds on which the court has decided that the plea is maintainable and how the arguments that were made by the Muslim side have been rejected. The highlight as far as the operative part is concerned is that the defendant failed to prove the plea was barred by either the Worship Act, by Waqf Act, or by the Kashi Vishwanath Act.